so I guess in light of the weather, let's see what players are missing today. So I had Jadida, your DCF. We don't have any district attorneys here, so.
We can just have a discussion if you want.
Remind me, Ash, because I knew you were going to talk about something.
That was Tim.
That was Tim? Okay, yes. And there was someone else. Nadej, okay, good. So we'll start with you guys. So we have Tim representing Alicia, Ash representing Jason here, Nadej, Jonathan, Lester and John both for Lee, Jadida for DCF. I'll try to bring up the criminal issues, okay? And yes, I mean, we need to summarize. I want to get into, sort of all the issues that were covered in this case, and it's just tremendous. All the, and when I tell you more about the real case, there's even more convoluted, things that happened. So let's have a really quick discussion and try to tie up if you think that all of these parties could possibly arrive at some sort of, package deal on the criminal and on the care and protection case. Nadej, let me start with you because you're Jonathan's counsel, and I don't remember if I asked you anything specifically, but if you could comment, and I know some of the case law does talk about in care and protection cases specifically, when when children, in a family, more than one child, 3 children, 4 children, and so forth, are all the subject of a care and protection petition, and perhaps there aren't any specific allegations or very little or really very little evidence as to one child or more. What does the court generally say? What is the law generally as to whether a judge can find a father and mother unfit towards a child that's in a group of children in a family that is the subject of a care and protection case that goes to trial? Do you know what I'm saying here? So, for example, your client Jonathan has, there's no allegations, no evidence of child sexual abuse by his biological father, Lee. So even in a sense, maybe more of a claim, in terms of parental rights. Yet your position is that he should be free from alleged abuse and neglect, and that he should continue in the custody of the department. So where's sort of the law behind you to have that particular strategy? And if a judge agrees with you, and I'll open it up to everybody else, would the judge err? Is that suppose she took the opposite position, and yet the judge, found all 3 children in need of care and protection? Would Nadej, as counsel for Jonathan, have an appellate claim that the judge had erred?
Well, they usually, the judges usually look at the totality of the evidence and the proof that they have. So they won't really focus on Jonathan, but the whole evidence.
Okay. What else do you have? And that certainly is a piece of it. What do you mean by the whole, the totality?
Exactly what happened to Alicia and Jason, Justin report, and so they combine all these evidence together, and most likely the judge will find what's his name again, the father, Lee, unfit, as an unfit parent, because the judge might be worried about Jonathan being harmed in the future.
Okay, that's another good point. What do the cases say about either future fitness or future unfitness?
we have,
And in light also, let's consider her first point as well, that certainly a judge can consider that the child who's not harmed is still looked at in terms of the totality of the abuse and neglect. I'm going to use your own words, abuse and neglect to all of the children. In particular, the McHale case that you have, which a few of the cases that I gave you in this package were not typically child sexual abuse cases, but they dealt with some of these issues. And McHale is the case that I call it the cake frosting case. That's the way I remember this one. I just see this scene because the kids were allegedly, eating cake frosting for lunch. So that's how I remember the McHale case. But anyway, one of the issues that the appeals court considers is, I guess, one of the children, and I think it was Oscar, and I can't remember if he was younger or older, but I guess he had sustained like less emotional damage than the others. And these words may ring a bell for you guys. The appeals court says a judge does not have to wait for disaster to happen. In determining parental fitness, a judge may use past conduct to predict future ability and performance. Judge was entitled to focus on the constant inability or unwillingness of the parents to cooperate, and then they go into other issues. So even though there's no evidence that the younger child here, Jonathan, was abused, it could be possible that the judge would not be overturned on appeal based on that contention. Again, her position might have been otherwise because she's substituting judgment. So depending on the facts and the circumstances of the case, she could be advocating return home, and yet judge could rely on this proposition, and it may be a basis for appeal. Judita?
My question was, do they also consider the steps the parents take as far as rehabilitation for themselves?
Absolutely, and when you say that isn't really the word, but it's cooperation with the service plans, especially when the service plans are pretty much about every 6 months or so. So depending on the age of the case, by the time it gets to trial, there could be tons of service plans. In fact, if it's even going to go to the termination stage, those are also considerations that what we call the 210-3 factors. There's 14 factors, and many of those factors deal with the unwillingness or parents just being unable by status of whatever the condition is to really comply. Ash, you wanted to say
I was just going to say they would justify the removal of the children from custody of the parents, depending on their unwillingness to comply with the service plans or even their consistent inability to.
So that was the point and the reason why I specifically appointed a separate counsel for the younger child rather than counsel for all three children. Or obviously the reason that I appointed Ash, you and Tim separately was because I had Jason being younger than 10, so we can consider the 233 exceptions. And just to quickly summarize those exceptions now. 81 is the criminal exception, and because of the important due process and constitutional procedural rights of defendants in criminal cases, there are more stringent standards in 233A1. So remember, we went through and Jeremiah had mentioned it as the district attorney. Unavailability, and that could be a number of different reasons. In this case, he argued, well, it would have been traumatic for the children to testify, and thus they're unavailable. And if the Commonwealth even wants to introduce out-of-court statements, children under 10 in a criminal sexual abuse prosecution, they've got to do it ahead of time before trial. They have to give notice. They have to show an availability. The hearing itself has a standard, preponderance of the evidence that there's a compelling need for this procedure, and they've got to demonstrate both reliability and corroboration. Now it's funny because 82, which we didn't deal with because, you know, DCF's mission so far, DCF's purpose was only loss of custody in terms of the care and protection case. Jadida had mentioned, and so did Richard earlier, that they weren't moving for adoption or termination. But if they did, then 82 might apply as well, and that was the Quentin case. The SJC also held in the Quentin case that, you know, because the loss of now parental rights altogether is so much more serious than just the loss of custody in a care and protection case, that the procedures for introducing out-of-court statement of children in adoption cases are pretty much almost the same as the criminal. Yeah,
well,
Lester.
The court stated that termination of parental rights is the equivalent of a liberty interest.
Yes.
And so therefore must be held to a much higher standard.
Absolutely.
To a shadow of a doubt.
And in fact, there was another case, adoption of Carlos, that didn't deal with the statutory issue, but there's some very good language in adoption of Carlos, which explains the differences between care and protection case and a 210 an adoption case, and how the termination case is so much more serious. And you'll find that that in many cases SJC or appeals court may reverse and remand on termination, where the parents are unfit at trial, but it's just not enough, right, for the final step of termination. So yes, good point. And finally, with 23383, which would have been the process that Jadida and Richard in the care and protection case, if they wanted to introduce Jason's statements in the care and protection case, much less stringent standard. They don't even have to have a separate hearing. It could be a voir dire, could be an argument before the judge, and they just have to convince the judge that these statements would be reliable. So more than likely, Jason's out-of-court statements would be coming in the care and protection case. And again, they only would come in the criminal prosecution if all of those, you know, steps were taken, and if the judge ruled that in fact there was reliability and corroboration and so forth. Where was I? I just lost where I was.
Can I ask you a question? It's a little bit, I don't know if we're going to talk about later, but it's sort of about the article about the role of the attorney.
Yes, I do. You can bring it up right now if you want. That, you know, I believe I have all of the issues on the board. Okay. That this case study hasn't it? Hopefully, there may be more than I might have got on the board. Yeah, go ahead, bring up your
Well, I guess my basic question is, it seemed like an argument could be made for advocating for the child, and it also, whether or not, even if you, like, even if you don't believe it's in Jonathan's best interest to go back, he wants to go back, and so you serve the client's best interest.
Again, yeah, and substitute judgment, no matter that he's 4 years old, if he could make this adequately considered decision, if he was mature enough, would he want to be with his biological dad, or would he want to be free from harm, so to speak, right?
And I guess my question is, do the lawyers, when they try to go for the best interest of the child, or do they get in trouble? Do they get disciplined?
Okay. This was interesting because, as I said to you before, when the case first started, you know, by statute, all of the parties get counsel. So the 3 children were appointed counsel. Now, at the time, remember, they were living with Uncle Tony. So the third. So they spoke first to Helen and Kathy, then the same interview. Okay, so then the DA wanted to interview them. So this would have been the third time that they were talking to someone. So Tony brought them to the DA's office, and something happened. He got pissed off, or the kids were crying, or they didn't want to talk, and their attorney was there as well, and he fired the attorney, the court-appointed attorney, and then
Hired his own.
And hired his own. So DSS at the time filed some kind of motion, I can't remember what it was. I think it was to recuse or to, something to do with getting rid of, you know, the conflict of interest. It was conflict of interest because they were saying that, oh, he's the brother, then in actuality it's Lee who's funneling all of this and, you know, directing it and maybe even paying for it and so forth. So the judge did not allow DSS's, I'm saying DSS because they were called DSS back then, not allow DSS's motion, but appointed the GAL. As you probably guess, I was the GAL. And it was very astute of that judge back then to appoint a GAL, because here's the thing, in terms of role of counsel issues come up. Also attendant to that is a possible, you know, attorney privilege issues as well. So, for example, you represent the child, okay? And Jason, for example, this applies more to Jason and Alicia than Jonathan because he's too little to articulate anything. But Jason and Alicia are telling you, we don't care. We want to stay home with that. You know, we didn't engage in anything with our dad. Even if we did, we want to stay home. All right. And so, or they even tell you what happened, but say this is what we're directing you to do as our counsel. Okay. So now you're thinking to yourself, as counsel for the child, I have to represent that child's wishes. They seem mature enough to do this. It's a very obviously unpopular viewpoint. Is there a way for the court to understand that I can't do best interests, but somebody else better? But here's the thing. If you even ask for a GAL, are you then going to be disclosing a client confidentiality? So unless the judge recognizes there might be some kind of conflict and appoints the GAL, because that turned out to be a okay resolution at the time. But again, if counsel had brought it up, then counsel would have ended up disclosing a conversation that's obviously confidential. And I don't know if that's where you were going when you brought up role of counsel, but
Well,
those were the
think
role of
about it.
counsel
Yeah.
issues in this case. And that and they typically do come up in, you know, cases where the children are a little bit older, but there are very serious, you know, allegations. But again, Massachusetts is a client-directed model of child representation. It's not a best interest model. Best interest only goes to GALs and to, you know, and comes in as a standard, you know, in cases, in terms of terminated parental rights, for example. Tim.
What was that? I missed that. Massachusetts is a
Client-directed model. So that's role of counsel, John. So we were back at, is there any resolution? Now we know Cassandra, as the investigator, had summarized and then mentioned that her recommendation was that ultimately, perhaps with therapy and with other things in place, that reunification was possible. We heard that the children were doing well in school, had been doing well before. Well, now there was no obvious change or trauma in the condition at all. So there were a lot of good things in terms of, could you possibly keep this family together? Is it possible, however, For example, Lester and John, you at least counsel. What would you throw out as an offer? And you'd have to throw it out for both of the cases. Let me throw another nix into the mix. Which case goes first? They're both pending. And does it matter? And what would be better for your client in terms of which case goes first?
I would think the one with the higher standard. If that went first, well, it's interesting because you might reveal things might be revealed in the criminal
Yeah, no
trial.
matter. Each way is really tough. For example, we already saw that from the first 51A report, the DA is getting a 51A, the 51B, the service plans. So stuff has already been funneled to the DA. Your client goes to court and gets convicted, all right? If your client gets convicted, how can that be used in the care and protection case? What case have you seen here that
I think
can it come in? And if the conviction can be introduced to come in what way can it come in? In other words, how does the judge use it? Sheeta?
The Carla case.
Carla or Carlos?
Carla, adoption of Carla. It was in the criminal conviction.
Rebecca it was related to the mother, and the father had a criminal conviction, so I don't think that's right on.
Take a look at Jennifer. Remember, that was the case we discussed for another issue on Tuesday. We discussed it in terms of the judge can't substantively rely on statements as proof of the abuse if they came in only for state of mind. Remember, the children there where there were adequate statements and the anatomically correct dolls and so forth. But in that case, also the father had been. You have it, Ash?
I was just going to say it could only come in to the fitness as a parent.
Yes, yeah. Only is a big deal because that's what Jadita would do. She offer in evidence, a certified copy of it. And in fact, in Jennifer, it wasn't even his child was babysitter and still came in. So she'd be offering in evidence his criminal conviction. Again, that in and of itself is not. It can't be just that, but it's certainly a factor that the judge would consider relative to his fitness as a parent. On the other hand, what if the case goes the other way and the C&P is heard first? I'm just wondering, what again, as Lee's attorneys, if you could somehow direct the course of which proceeding goes quicker, which one would you rather have, Lester?
I would rather have the criminal case proceed immediately because the standard.
That's what John was saying too.
Standard is higher.
Yeah,
and in the civil case, in the care and protection case, the standard is lower, and my sense is the out-of-court statements, the hearsay statements are going to be admissible.
In the care and protection case?
Yes.
Yeah, and again, the only, not flaw in that, but if your client does get convicted, it's going to be used. But you're absolutely right. The holes in the case relative to the criminal case In other words, the whole, in the district attorney's case, in terms of the evidence the district attorney has. 23381, again, if all of those safeguards are met, Jason's statements might come in. Alicia's, again, but just the excited utterance perhaps, because even state of mind may not come in the criminal case, because the kid's mental state is not at issue in the criminal case. It's at issue in the care and protection case because it's abuse and neglect of children. So you might not even be able to get Alicia's or any of those state of mind sort of exceptions in the criminal case. So I agree with both of you that you would probably be pushing for the criminal case to go first. And remember the whole first complaint, fresh complaint issues as well. You don't have the corroboration of anyone else. I'm sorry, of the victims. So whether you're in the context of the criminal case or the care and protection case, if the other side is going to be, if the department or the state is somehow going to make the argument, oh, judge, it's not hearsay, it's coming in as first complaint, then the defense's argument should be, no, it's not. Look at Amaral, look at Avila's. You've got to have the victims testifying as well. The person that's testifying to the first complaint is merely corroborating what the victim would be saying. And then we also discussed, again, in the criminal case, if the district attorney was looking for, some other method of, say the children wanted to testify, but then, the whole issue of them being traumatized by the court testimony and whatnot, there has to be, it's highly unlikely in terms of the Massachusetts higher standard regarding face-to-face. Even though, the Bergstrom Court and the Johnson Court did say that, well, we're not going to say it's absolute across the board in every situation. So, following Maryland v. Craig, let's look at it case-by-case basis. Necessity, is there a compelling need? But at the same time, balancing and keeping in mind defendants' right to face-to-face. So again, the defense seems to have what we call a good case, in terms of maybe being found not guilty. Yes.
It almost seems like in the care and protection case that it's a good case in the sense that, well, I wonder what other things can prove the reliability of, because that's one of the things that I was reading about in the Rebecca case was
right.
That the judge he relied on the out-of-court statements, but he couldn't find another means of corroborating them or showing that they were reliable.
Janita, what do you think? If you were going to make an argument that Jason and Alicia's, or at least Jason's, statements were reliable.
Well, definitely the first or fresh testimony, because they stated that many times children, they will recant once they realize that the family could be separated or they won't go back to their parents, then they start to recant their statements out of fear.
And I don't remember if this was on the video or not, but statistically, children don't often fabricate abuse, sexual abuse by a caretaker, and do often recant, as you said, because of feelings of guilt, tearing the family apart, etc. Could the judge rely on that for reliability?
I think they should, along with getting these children tested, like psychologically, and all of these things together, because it's such a it's difficult to have like one by itself. For example, in getting those children tested to see whether they would be traumatized if they come into court to testify. If they will be, then of course